In a city that has seen its share of political spectacle, even a sandwich can become a flashpoint. Federal prosecutors in Washington, D.C. have failed to secure a felony indictment against Sean Charles Dunn, the man accused of hurling his lunch at a U.S. Customs and Border Protection officer. It's a rare setback for prosecutors and a vivid illustration of the tension between federal power and local sentiment. The incident unfolded on August 10, 2025, in a bustling nightlife district. Dunn, a 37-year-old Air Force veteran working as a paralegal at the Department of Justice, confronted a group of CBP officers. Video, later posted online, shows him shouting profanities, calling the officers fascists, and insisting, "I don't want you in my city." He then flung a submarine sandwich that struck one officer in the chest. The federal response was swift. Armed agents arrested Dunn, an image featured in a White House social media post. Attorney General Pam Bondi fired him the same day, and U.S. Attorney Jeanine Pirro announced she would pursue the felony charge of assaulting, resisting, or impeding a federal officer, an offense punishable by up to 8 years in prison. He thought it was funny. Well, he doesn't think it's funny today, Pirro declared. That aggressive posture fit the broader climate in Washington. President Donald Trump had recently ordered a surge of federal law enforcement and National Guard personnel to the city, calling it a response to a crime emergency. Many residents and local officials viewed the deployment as heavy-handed, setting the stage for friction. With that backdrop, prosecutors took the sandwich case to a federal grand jury. Grand juries meet in secret, hear only the government's evidence, and need find only probable cause, a far lower bar than is required at trial. Hence the legal adage that a prosecutor can persuade a grand jury to indict a ham sandwich. Yet, on Tuesday, August 26th, jurors refused to indict Dunn. Legal analysts called the decision a remarkable rebuke of the government strategy. Some describe it as a form of jury nullification, citizens declining to greenlight a prosecution they see as disproportionate. Others simply call it overcharging, pursuing a felony where a misdemeanor usually suffices. This isn't the first stumble for Pirro's office. Grand juries have recently declined 3 times to indict a woman accused of assaulting an FBI agent, forcing prosecutors to downgrade that case to a misdemeanor. D.C. magistrate judges have likewise complained of due process shortcuts in other surge-related arrests. For Dunn, the legal path is still uncertain. Prosecutors could try another grand jury, scale the charge back to a misdemeanor, or abandon the case altogether. Under the Speedy Trial Act, they have 30 days from his arrest to secure an indictment. A preliminary hearing is set for next week. Beyond the individual stakes, the episode speaks to a larger story: how far Washington is willing to go to project toughness, and how ordinary citizens, whether on a sidewalk with a sandwich or in a jury room, might push back. In this clash between federal authority and local conscience, the grand jury's silence was louder than any courtroom argument. From a tossed lunch to a legal showdown, the case of Sean Charles Dunn underscores that even small acts can expose big divides, and that in the nation's capital, the battle for power, perception, and justice can hinge on something as simple as a sandwich.